This is, I think, the sixth in our series of webinars around employment law and HR issues that we've been running since lockdown. This morning, we'll be looking at the changing landscape of employment tribunals. I'm joined by my partner, Rebecca Thornley-Gibson, and we're both delighted that Gary Self has joined us today. For those of you that don't know Gary, he is a barrister at 3 Pump Court Chambers in Temple, and he also sits as a part-time employment judge. So we're very grateful to him for sparing his time today, because I think he'll be able to share with us some very helpful and useful insights, certainly from 2 sides of the triangle in an employment tribunal, as a representative, often I think for respondents, but not always, but also as an employment judge. So just a couple of housekeeping points. I think our session this morning probably run for about 50 minutes to an hour. We'll try and take some questions essentially as we go along. Please do submit your questions. If you have a question, please use the Q&A facility on Zoom. If you have a technical problem or some other issue, then by all means use the chat facility, and a member of the team will try and help with that. But as I say, if you have a question for the panel, please use the Q&A facility. Okay, so we'll probably get going if we can now. And the first section that I'm going to deal with is looking at the Employment Tribunal roadmap. And we're going to start off then this morning with a poll for you. And the poll really asks, have you had a hearing that was due to take place since Easter 2020 cancelled, or possibly converted to a case management hearing? So I think the poll should be up there for you now. If you could vote on that, that'd be grand. Thank you, and hopefully we'll have the results come through in a moment. That's lovely, thank you very much. And interestingly, there's actually only a very small proportion of you that have had that occur, and overwhelming majority where it hasn't. I suppose probably the 3 panel members have all had the reverse experience, but that's probably a function, obviously, of the nature of our roles and jobs. So if we move on, perhaps then, to our second poll. And so this one is asking just the more general question is, have you attended a virtual hearing previously? And again, hopefully we'll have the results in just a moment. That's terrific. And again, overwhelming majority haven't had the pleasure of a virtual hearing so far. So hopefully a lot of what we're going to talk about this morning is going to be helpful and relevant to the overwhelming majority of our audience today. So moving on then, the Employment Tribunal roadmap. Now this is essentially something that's been put together by the President of the Employment Tribunal in England and Wales and the President of the Tribunals in Scotland. And it seeks to set out a framework in terms of what essentially is going to happen as regards the running and management of cases for the remainder of this year. The document talks a bit about the new technology that is in the process of being introduced, and also about the approach to the grading of cases, quite explicitly outlined in the document. And then if we go on, the new technology is something called the cloud video platform, and that essentially is something which the Ministry of Justice are using in a lot of different court settings. And in the context of the Employment Tribunal, 150 hearing licenses have been obtained. And that means that potentially at the moment there could be 150 different tribunal hearings going on up and down the country. And that's only a small fraction obviously of the total number that potentially could or would have been happening at any one time. What's going to happen is that the employment judges will first of all be trained on the use of the cloud video platform. That I think is pretty much just starting underway now, and we'll hear from Gary in a moment as to whether or not he's yet been part of that sheep dip. And then the lay members of tribunals are due to be trained later on in the summer. The current approach, though, without the cloud video platform, is very much a hybrid approach. And again, we'll hear more from both Gary, I think, and Rebecca on this. But essentially, at the moment, individual tribunals and individual judges even are deciding what technology, and that might well be Teams or it might be Skype for Business. Those seem to be the two most common ones sort of at the moment. So we go on then in terms of the types of cases. Well, what the roadmap sets out essentially is categorization of cases into three types. The first being referred to as short track. Well, generally those are money claims, maybe claims for a statutory redundancy payment or notice pay, or possibly an unlawful deduction from wages claim. And then the standard track, so that will generally be what I'll call ordinary unfair dismissal claims. Those would be cases, of course, where an employment judge nowadays sits alone doing that. We don't have the industrial jury anymore. And then finally, the open track, which would be the more complex cases generally, and the longer cases involving claims of discrimination and whistleblowing. Those would probably be the two main jurisdictions that would fall within that. And then in terms of the roadmap, we have the 4 phases of hearing. So we have what's happening essentially this month, then July and August, September and October, and then towards the end of the year, November and December. And it's basically a graded and a stepped approach with an initial focus on getting through as many case management hearings as possible, judicial mediations, and what are termed priority hearings. Unfortunately, priority hearings are viewed as being very specific types, generally things like interim relief in the context of a trade union representative. Priority hearing, unfortunately, isn't, simply because both parties would like the matter dealt with as a matter of priority. And then within this, these 4 phases, there'll be this gradual reintroduction of in-person hearings, as well as the open track cases that I've just referred to a few moments ago. So I guess now if we look at sort of some of the current experiences in the Employment Tribunal, and I'll hand over, if I may, to Rebecca, and then I think she and Gary will share with us some of their experiences and observations. So Rebecca, over to you.
Thank you, Rustam. So interesting that the vast majority of you haven't had the pleasure yet of virtual hearings. So hopefully our experiences can give you a little bit of being forewarned for what could be a brand new experience for many of you. So myself, since lockdown, I've been involved in a couple of hearings, both of which have been preliminary hearings on a remote basis. And they are completely different to being in person at the Employment Tribunal. And there's a number of practical logistical issues relating to that, a number of issues relating to use of electronic bundles, and I think also sort of issues relating to evidence and how evidence is given. But if we can just look first of all at some of those practical logistical issues, and I start with technology. Now, technology needs to work for everybody involved. So the employment judge, the representatives, the witnesses. And therefore you may have a considerable number of people all involved in those employment tribunal proceedings in that remote hearing. So you really need to make sure that prior to the hearing itself, you perhaps as the employer respondent have checked that your technology works and the technology of any witnesses that you are relying on also have the right technology. And that's both in terms of as Ruston said, the tribunals will move towards the cloud video platform, but at the moment it is a hybrid. It is a potential Microsoft Teams. Those are the platforms that I've been involved in my remote hearings so far, but it could be Skype. It could, of course, don't let's forget telephone hearings. We've had telephone hearings for many years now, so telephone hearings are still an option. And I'm sure many of you have been involved in telephone hearings before, but you need to work out with those people that are involved that they can use the tech, that things such as their hardware is going to support the apps, that their Wi-Fi is going to be hopefully reliable. And as an employer respondent who may be asking witnesses to be involved, you know, do they have the right devices? What I found is that you absolutely need 2 devices. You need a video on one device, and you'll probably be looking at documents on another device as well. And not everybody does have 2 devices at home when working remotely. So just make sure that you check those things out. Court etiquette. It's very easy to slip into the, well, I'm at home, so actually I'll just rock up and switch my laptop on and, you know, there I'll be on video. You are in court, whether you're in your dining room, your office, wherever you are in your home or wherever you are remotely, you are in court and subject to court and tribunal rules. So, you know, etiquette is key. Etiquette will be making sure that you are dressed properly, which might seem very obvious, but, you know, dress as if you were going to the employment tribunal. Make sure that you are somewhere where you're not going to have interruptions. So, you know, you don't want somebody walking in behind you midway through your witness evidence. Make sure that, you know, you're not there swigging from a cup of tea in an inappropriate mug. It's fine to have a glass of water as you would in tribunal, but, you know, remember, this is all about a court hearing still. So do remember the etiquette. I think it's really important that nobody is recording the hearing. Nobody is taking screenshots of what's going on. The employment judge will set that out at the beginning, but I can see, you know, some improper practices by perhaps inexperienced, you know, and non-legal representatives who might decide to start recording hearings. That's an absolute no. What I think is quite interesting is the confidentiality and privacy that people will expect from a remote hearing, but there are many hearings that should have public access. And that, I think, is something that's going to be interesting to work through, how public access to remote hearings is going to be addressed. And I'll be interested to hear from Gary on that in a few minutes as to how the public are going to be able to access remote hearings where it moves into a substantive hearing. And I think the other thing that needs to be considered is the speed of the hearing itself. I have personally found that the hearings have been slower. It's quite intense being on video for a full day. Both of my hearings, although they were preliminary hearings, one was a half-day hearing and one was a 2-day hearing. And being on video, sort of on all of that time, is pretty intense. I think when people are giving evidence as well on video, it'll feel quite intense. So there will be more breaks, and there will be a tolerance that perhaps the unexpected might happen, like Wi-Fi, etc., might go down. So speed of hearing perhaps needs to be considered for things such as listing of hearings as well. So perhaps a 1-hour prelim in person actually is a 2-hour prelim when it's a remote hearing. But if we can move on to some of the other issues that we are now finding are perhaps new to us with regards to remote hearings. And one of those is in respect of electronic bundles. Most of you will have seen us carting copious amounts of paper to the Employment Tribunal. One advantage of a remote hearing is that hopefully we will save our shoulders and our backs, and that we're not having to cart those lever arch files around. But we are going to have to be much more prepared with the paperwork that we are providing in the proceedings, and e-bundles, electronic bundles, are going to need much more focus prior to the hearing. So an e-bundle, effectively, you're putting together all of your paperwork into sort of one PDF, effectively. Lots of e-bundle software out there. But consider the situation where suddenly you get to the hearing normally and you find there's half a dozen documents that are quite important that haven't, for whatever reason, been included in the bundle. Now, however annoying it is for the employment judge and perhaps the other parties in that situation, the tendency usually would be for those half a dozen pieces of paper perhaps to be accepted, and you can pass them over to the judge or to the other side. That is not the same when you're doing a remote hearing. So you're not going to be able to just suddenly say to the employment judge, "Oh, can you give me your email? I'd like to send you some bits of paper." That is not going to happen. So if you haven't included the correct documentation, that is not going to be available for any of the parties or for the employment judge to see and rely on. So do make sure that that e-bundle, and we'll make sure with you, obviously, is in a good form. I think there is, there's going to be a different approach to giving evidence and cross-examination. Gary, as an advocate and as an employment judge, will be able to give his view on that. But I think we'll probably, see still robust cross-examination, but I think it's perhaps, a tendency not to be sort of perhaps saying quite as aggressive cross-examination when it's a remote hearing. We can't see things in quite the same way like body language. We can't see the reactions of other people in the employment tribunal when somebody is giving evidence either. And I think that's a potential difficulty for advocates. Consider how you're going to take, we certainly have to consider as advocates how we're going to take client instructions during the hearing. Again, we won't get that tap on the shoulder or a note being passed to us. So it might be that, we have to agree with the client that they are going to send us their instructions via email or perhaps on WhatsApp, or we will have to simply ask the employment judge for more regular adjournments to enable those client instructions to be taken. But prior to the hearing, those are the sorts of things that we will need to work through. You won't be able to do it once, once the screen has gone on and you're partway through the remote hearing. So there's a lot of preparation, a lot of how are we going to do it that needs to take place between us as the advocates and our clients. And preparedness really is key to making sure that a remote hearing goes as smoothly as it possibly can. But I'm going to pass back to Rustam, who I think probably will have some questions, particularly for Gary, to enable Gary to give his view from the bench, as it were, and also his view as an advocate.
Thank you very much, Rebecca. Yes, indeed, it's Gary's turn now. So, Gary, first question really for you. What has your experience been so far in relation to remote hearings? That's the first question. And then sort of linking on from that, do you have a view as to perhaps when they might advantage one side or another? And of course, you might have a different view as an advocate than opposed to when you're sitting as a judge.
Yeah, thank you, Rustam. My general view is very positive towards the way that it's been put in place so far. It's an incremental approach, but if anybody has a thought out there that this is a temporary expediency, it's not. The tribunal system has been looking for years for ways to deal with remote hearings. There's always been a reluctance to deal with video hearings, but now, like much change, now this has been forced upon them. I think that the landscape for these hearings will be here forevermore, especially dealing with the more straightforward matters, the short track cases, Wages Act or the unlawful deduction sort of claim, and also indeed for straightforward unfair dismissal claims. The main message really to everybody is that it's stressful and worrying enough having a tribunal, no matter how experienced you are in any event. There is no need to become increasingly worried and stressed about dealing with hearings such as these. The reality is that you just need to make sure that you put in place all the building blocks that you would normally do. For instance, there is always, once the hearings get up and running, they are largely reasonably seamless. But there is always problems with everybody signing in and getting the administration sorted out at the outset. So at whatever time you are suggested that you should be dialing in, a mad scramble in the last 5 minutes is not going to work. And all that then does is increase the stress levels. And it seems to me that there's nothing which is more irritating for a judge when they are ready to go and other people aren't. So therefore, if one is looking to create a good impression from the outset, make sure that you're there in good time. The second thing, and I endorse what Rebecca said, is again, all of these cases are always about preparation in any event, but it's harder to fix things when things go wrong. As an example, we as lawyers may have an idea about how things work, but for instance, giving evidence is not something which people are used to doing. Working through a bundle, many employers are not used to doing it. To you, it might be obvious. And if you are at the tribunal, it is easy to fix if your witness does not go through things in an appropriate way, because you can bring it to their attention and assist them there and then. Remotely, it is not quite so straightforward. And so therefore, that preparation and actually prepping the witness as to what is going to take place, I think is absolutely vital. Just in respect of hearings themselves, however, I mean, I've done a range of hearings, and as I say, in each of them, I think that that the remote setting has worked very well. I was fortunate enough to go to the Court of Appeal, and that is an ideal circumstance for a remote hearing. Firstly, from my own perspective, it gets rid of a lot of the pomp and circumstance that one would normally have at such a hearing. And there was a levelling basis as an advocate to have the two Law Justices sitting in their respective studies in the same way that you are. And the Court of Appeal hearing was worked very well and very efficiently. Indeed, I suspect was more efficient than had we been there in person. I've done a fully contested hearing on an unfair dismissal claim, in fact, instructed by DMH. And again, even though the claimant was acting in person and he was going from a mobile phone, that worked seamlessly over the 2 days. Issues whereby there are matters to be raised in cross-examination. There have been concerns that there may be worries about whether a just result will accrue because of the differences. But once again, the cases that I've done thus far, there is no material difference to the outcome as opposed to whether one is in person or not. And so these are the main message is there is nothing to be scared of. If you are prepared, if you are ready, and if you think about things, then in those circumstances, these are an opportunity as opposed to a threat.
Gary, thank you. That's very interesting. I'll just pick up one point. In fact, I think I'm aware that it happened in the hearing that you've just referred to, where one of my other colleagues was working on it, and that's the concern that perhaps one of the witnesses is being prompted, because of course in an ordinary tribunal situation we always have that issue of the witness having to go up to the witness table and only look at the bundle, and of course we often get people who then try and put some notes out from their briefcase and start looking at those, and of course that is absolutely forbidden. So what is it that, in terms of as to what you can share, how alive are judges essentially to that concern? That, and of course it could be both parties, to be clear, it could just as easily be a respondent trying to do it.
Absolutely. Well, as an inherently suspicious person, especially when sitting, I think one always has to be very alive to it, because what can't be compromised. In any hearing, what one seeks to do is to ensure that there is fairness and a just outcome. And of course, any interference with witnesses or prompting in that way is something which goes to the very root of that. So the reality is that we are very alive to it. 2 points, though, really arise, Rustin, from what you've just said. The first point is this: is preparation is all important. For us, for instance, for most of us, for instance, it would be logical to keep the bundle in page order in a ring binder. And you would think that you wouldn't need to explain that, but other people have different ways of working. And in a circumstance recently, one of our witnesses decided to completely dissect the bundle and place them all over the place on the floor elsewhere, and there was chaos. Now, that's a very good learning point for me, because now it's quite clear that sometimes you do have to say what would appear to be obvious in order to obviate such problems. The other issue is about witness interference. And there's a story doing the rounds amongst employment judges of a witness who was giving evidence in front of a large window. And in the window, one could see her husband prompting her and directing her and holding up signs. And so therefore, of course, that wouldn't be appropriate. But in a hearing, it's not appropriate at all. But of course, that's the sort of thing which people, if there is a third party in the room and somebody is having difficulty, it's a human instinct to go to their assistance. And so therefore, there needs to be very, very clear ground rules. And this sort of, you must be in a room and you should be on your, and you must be on your own, is absolutely inviolate. And so therefore, otherwise, it will cause great problems.
Gary, that's really helpful. Rebecca, just before we move on to the next topic around vulnerable parties, I wonder whether you just had anything particular that you wanted to add, either from what Gary said or just more generally.
I think I'd be interested to hear from Gary as to how the tribunals will allow public access to the tribunals that would normally obviously be in person, and how that's going to work, because, you know, effectively, I think that changes the dynamics when you know that you've got several other people probably watching you as well, sort of on video conference at your remote hearing.
It is clearly a problem, because openness of justice is something which is very, which obviously the Employment Tribunal is very keen to promote. The reality is in my experience, from a publicity perspective, often the effect or the interest that specific tribunals hold is perhaps more limited than people might see who are caught up in the midst of them. But for instance, I know certainly in one tribunal centre, and certainly in the centre that I sit, the way that they are going to deal with that is to effectively have 2 rooms available. So therefore, there will be the hearing room where the judge is sitting, or if it's remotely at their property. But then the case will also be listed at the Employment Tribunal, and therefore there will be a room available whereby the hearing effectively will be streamed. So that's the means by which it's anticipated that the publicity matters are likely to be dealt with.
Terrific. Okay, thank you both. Just to ensure we keep to time, I think if we move on now to the next section, and this is looking at vulnerable parties. And again, I think this is an interesting one in the context of sort of balancing the adversarial process that fundamentally we have with obviously the desire to ensure that vulnerable parties are not unfairly disadvantaged. And Rebecca, I think you're going to, again, sort of give us some of the broad background, and then again, it would be great to hear from Gary as well with his views. So Rebecca, I'll pass back to you.
Thank you, Rustam. So I think that the presidential guidance that was issued on the 22nd of April in relation to dealing with vulnerable parties in the tribunal has perhaps slipped under the radar a little bit, with all things furloughing and COVID-19 issues and redundancies and return to work, I think people tend to forget that there are still other things that are ongoing and need to be considered. So if we just move on to the next slide and have a look at what this presidential guidance on vulnerable parties is and what it means, hopefully we can sort of update you on a new consideration that you're going to have when you're involved in employment tribunal proceedings. So, as I said, 22nd of April, we saw an employment presidential guidance issued. And the purpose of that guidance was to ensure that the employment tribunals and the employment judges should have regard to the needs of vulnerable parties in the employment tribunal proceedings. Now, that presidential guidance is to be considered as part of what we call the overriding objective of the tribunal, to make sure that all parties involved in the proceedings can effectively participate in those proceedings, and that witnesses can give their best evidence, that they're not disadvantaged because perhaps of their concern about the tribunal proceedings and because they are a vulnerable party. So it's quite, I think, quite a task to try and work through, you know, is somebody a vulnerable party in the employment tribunal proceedings? I mean, first of all, who can be a vulnerable party? Well, that can be the claimant, the respondent, or any of the witnesses involved in the proceedings. So it covers those those categories of individuals. But the interesting issue is, how will vulnerability be determined? There isn't a single definition in the guidance, but a good test, which is set out in the guidance, is looking at whether the individual is likely to suffer fear or distress in giving evidence because of their own circumstances or those relating to the case itself. Now, I think everybody would think that arguably most of us, most witnesses, would probably, you know, be anxious about giving evidence. As Gary said before, it's not a pleasant experience necessarily, and you know, it's not as though people will look forward to giving evidence. But being anxious is probably not enough to determine that you are a vulnerable party. And what the employment tribunal, what the judges will do, is they'll need to assess vulnerability by reference to things such as mental and physical disabilities, intellectual or social disadvantage, and actually there's a range of other assessment guidances to consider vulnerability. So trying to identify a vulnerable party is going to, I think, be quite difficult. And if we can just move on to the next slide, one of the questions is it the responsibility of the respondent employer, for example, to identify a vulnerable party at an early stage in the proceedings? Now, there is a suggestion in the presidential guidance that that might be something that is done when the ET3, the response, is filed. It might be something that the claimant themselves do when they file the ET1. At the moment, the ET1 and ET3 forms have not been changed, or they certainly hadn't when I looked at 9 o'clock this morning, but they certainly haven't been changed to, you know, include a box to identify a vulnerable party. Yes, you can tick a box to say whether you have a disability, but there isn't anything to cover the vulnerable party consideration. So if there is a vulnerable party on the claimant or the respondent side, and that is something that is likely to impact on the proceedings itself, it probably is going to be a good idea to set that out in the ET1 or the ET3, so that the tribunal are aware, and the tribunal can then consider their approach on the proceedings, because one of the one of the things that the employment judges will do is they will look at whether they need to set ground rules or what orders might be needed where they consider that there is a vulnerable party in those proceedings. And in deciding whether to set ground rules, in deciding whether to set specific orders, they'll look at a range of factors. And those factors might be the mental and physical health of the individual, intelligence or social functioning impairment, whether the individual's undergoing any current medical treatment, their age, maturity, understanding, domestic circumstances, religious beliefs. So there's actually quite a lot of information, personal information you might need about an individual and the impact on the proceedings if you want to perhaps ask the tribunal to set some specific ground rules and put in place a range of measures and adjustments for that vulnerable party. Now, quite what those range of measures and adjustments may be, it is still the Employment Tribunal judge's discretion, but the sorts of adjustments that are mentioned in the presidential guidance that I think are quite interesting and could impact on litigation and strategy are things such as extending time for compliance with directions. So I'm sure you've all been involved in situations in tribunals where the other side have perhaps been late with compliance with orders, be that lists of documents or witness statements. It may be that a vulnerable party is given more time to comply with directions, and that might be an extension of time when they've been unable to comply with the original orders. And whereas normally we might suggest that you get quite cross with the other side about that, and that you put in an application for what we call an unless order, which is unless they do something, there is a penalty. Where you have a vulnerable party, that's something that you probably would not be advised to do, and there may even be a ground rule that actually the vulnerable party has got more time, will be given more time to enable them to participate fairly and on a level playing field in the proceedings. But there may also be a range of measures and adjustments such as perhaps pre-recording the evidence. So a witness who's very, very anxious about giving evidence may be far less anxious and may be able to give their evidence if it's pre-recorded, or perhaps if it's done by a video link. There may be reporting restriction orders that are granted by the Employment Tribunal, perhaps in respect of sensitive parts of the evidence. So although the tribunals can already make orders in respect of reporting, there may be a greater number of applications asking for reporting restrictions in respect of sensitive witness evidence, particularly where it might involve health issues, or it might involve confidential business information, or it might involve issues of sexual harassment, for example. There might even be questioning of the witness by an intermediary, or questioning by the judge rather than the opponent's advocate. So it is really about bringing the vulnerable parties sort of into the proceedings so that they aren't disadvantaged by any of their vulnerabilities, as it were. And I think that both advocates will have to take perhaps a more, ethical approach to their litigation and their examination where you have vulnerable parties. And I think particularly employer respondents will have to accept that some of the litigation fight, as it were, that they might have wanted to have had needs to be a little more muted where vulnerable parties are involved. So hopefully that gives you an overview of the expectations now, the extra expectations that the tribunals have where there are vulnerable parties. And again, I'll pass back to Rustam and hope that Gary can provide some insight from the judicial side.
Thanks very much, Rebecca. Yeah, well, why don't we start with the very last point, because I suspect Gary may take a different view, just as to the extent to which representatives are, as it were, going to have to be more careful, and possibly some of, as you, to use your expression, Rebecca, some of the fight might come out. Gary, do you have a view on that?
Well, that would worry me. No. In a sense, you see, when I'm doing it from a respondent perspective, the view that I always take, both as a judge and also as an advocate, is that we're only there because the claimant wants to be there. It is there's no respondent who voluntarily goes to a tribunal. It's always claimant led, and that's one of the frustrations in respect of it. But to some extent, yes, we now have presidential guidance, but the reality is, I'm not sure that it actually. I think it actually says within the document there's no need to reinvent the wheel, and I'm not entirely sure, apart from placing it perhaps more at the forefront, that there's actually any material difference to that which has gone on before, because ultimately we deal with the overriding objective. The overriding is to deal with cases justly. Any judge worth their salt will have all of these various matters in their mind anyway, because what I can assure everybody, although it may seem differently, there is no judge who walks along to tribunal in the morning who thinks to himself, I really hope I've got a difficult day ahead of me with a very difficult person, and I'm going to make it difficult for everybody. Now, that's what most judges, I'm not saying all judges think that way, but that's what most judges will think. So the reality is in actual fact, most judges will bend over backwards in order to facilitate, in order to make sure that a fair and just hearing takes place. And effectively, the presidential guidance, it's not binding upon anybody. It's purely, as it says, guidance. And actually, it is, from my perspective, merely reasserting those things which I have undertaken as a judge throughout my career. And there may be some people who've been in front of me outside who may say, well, not the hearing he did in front of me. But that's certainly what I seek to do. The other point, two other points, I think, Ruston, which is quite important, is firstly, a good advocate is one who it can be chameleon-like, so therefore who adapts to the circumstance. There are circumstances where to be hostile and aggressive is an appropriate stance, but not all the time. Sometimes it's far more effective to just lure somebody along the way in order to mug them at the far end. So therefore, what one has to do is to make sure that you adapt to each person. The other thing which, again, this is clients very often want to be very, very harsh or very, very strong, as they see it, in correspondence by making ample cost warnings and cost threats and then sending that into the tribunal. I would certainly counsel against that. If there is a good reason that the case has very little chance of success, then make sure that's clearly set out, and therefore there is a context to the cost warning. Sometimes, and the one thing which does irritate judges when they're going through their box work is effectively empty threats, which are just simply perceived as being bullying and actually end up being counterproductive for the respondent. And so therefore I would certainly counsel against that, and especially if there is the thought that there is a vulnerable witness. And I do agree with Rebecca that certainly for the time being, tribunals are going to be far more on their guard in order to ensure they don't fall foul of this guidance.
Gary, thank you. Very comprehensive and obviously very helpful and interesting to hear. Gary, also, I see that you've been replying to some of the questions that some of the delegates have been putting, and that's great. Perhaps we'll come back to a couple of those if we have time at the end. But those of you that have asked questions, you'll see Gary has already put some responses down there for you. Just to be clear, in relation to the questions, we will, after the session, as we have done with all of the other sessions, produce essentially a kind of a follow-up Q&A sheet, which will circulate to everyone that's registered for today. So I think what we'll do now, Rebecca, if that's okay, is we'll move on now and just look at this issue of the changing dynamics of claims and settlement, bearing in mind where we are at the moment. So over to you, Rebecca.
Thank you, Ruston. Yes, this is very much our observations. It's not necessarily what will definitely happen, but it's sort of our observational sort of experienced sort of view on what we think is likely to happen to claims, and how you might want to approach settlement because of recent COVID-19 issues, and because of the inevitable sort of rapid pace of change sort of in the employment sphere over the last few months. So the employment tribunals, I think it's fair to say, anybody that's been involved with employment tribunals, certainly over the last sort of 12 months, will know that they are already relatively stretched in respect of the administrative resources they have. And if we just move on to the next slide, we can probably see that sort of stretched and sort of admin resource light approach that the tribunals have or have had over the last sort of 12 to 18 months is likely to be even more stretched, with an inevitable increase in employment tribunal claims arising from a range of factors over the last few months, be that, you know, furlough decisions, be that redundancies, be that pay cuts. But we are starting to now see what was originally a relatively grateful employee population when people were furloughed, starting to move into a more tense employee relations dynamic now, and that will move into an even tenser dynamic if those employees lose their jobs, and they will be looking to put claims in, particularly because the employment market is probably going to be one of high unemployment, so they're not going to be able to walk into another job within a couple of months, and therefore they might as well just bung their tribunal claim in after going through ACAS early claim conciliation. One caveat with that, however, perhaps not for the next 12 months, but possibly in the next 18 months, is you may have seen some publicity earlier this week around the possible return of tribunal fees. Now, it is something that is in discussion, albeit in discussion at a formal level, but there could be a return to employment tribunal fees, which were abolished in July 2017, but that return could see a slightly different employment tribunal regime with lower fees for claimants on issue, but having a fee payable by the employer when the T3 is lodged. So that might be something that is going to try and promote employers to settle before they have to pay to lodge the ET3 response. So we'll be keeping an eye on that. The other thing, just to say in terms of current tribunal workload, is that it's pretty evident that when you issue a tribunal claim and then you get the notice of the first hearing, which is inevitably the case management hearing, the time between issue of that claim and the first hearing is increasing and will, I expect, increase further, even with video hearings being put in place to try and stem the delay. But for example, I had a tribunal that was issued in February of this year. Our first case management hearing is not until the end of October. So when you have to wait 10 to 11 months before you get to first hearing, you start to see how stretched the employment tribunal actually is. So the types of claims that we think we're probably going to see more of are on the next slide, and we're looking at more claims in respect of redundancy, unfair dismissal. So employers to carry out a fair redundancy should be consulting, they should be selecting fairly, they should be, consideration to the pools in the selection, the pools for redundancy, looking at alternative vacancies. Now, there probably weren't that many alternative vacancies to look at the moment, but there certainly are still legal obligations in respect of consultation and legal obligations in respect of a fair selection. So we are expecting a significant number of employment tribunal claims on the back of probably flaws in selection processes. And whilst the tribunals, may not want to interfere too much in the actual redundancy decision, and they might not want to interfere too much in perhaps the pools that we used, they certainly won't let employers carry out unfair or discriminatory selection in relation to redundancies that need to be made. So those are probably going to see an increase. Lots of employers have put in place pay cuts to deal with COVID-19. Again, sort of at the beginning of lockdown, at the beginning of the crisis, a lot of employees were grateful just to have jobs and agreed to pay cuts. But they agreed to pay cuts on a temporary basis. And what's happening now is that employers are asking for those pay cuts to be extended, and employees are actually saying, no, actually, we were prepared to do it for a temporary period of time, but we are not prepared to continue to have a pay cut. Now, some employers may decide that they are going to impose that pay cut, and if they do, then they will inevitably end up with claims relating to unlawful deductions from wages. I think as well, we'll probably see a rise in whistleblowing claims, health and safety concerns, where people are concerned about returning to work. They're concerned that perhaps employers haven't carried out the right risk assessments, and they're concerned that perhaps they're being asked to return to work a little too early, and they raise grievances, they raise concerns about those issues, and then they may suffer a detriment by raising those concerns. So I think we'll probably end up seeing some whistleblowing claims increasing, and some detriment claims from raising health and safety concerns. So in terms of what settlement options you might have, if we just move to the next slide, the approach to claims and the approach to settlement by employer respondents might need to change from what it currently is. So, as I said before, I think we're going to see high unemployment. I don't think that's a surprise to anybody on the figures that have come out so far. But with high unemployment will also come a risk of higher financial awards in the event of successful claims. So do you risk not settling, particularly if you know that you've got a weak case, when it is probably going to be the case that the employment tribunals are going to be awarding perhaps maximum compensation in respect of unfair dismissal cases, because somebody genuinely has not been able to mitigate their loss by seeking alternative comparable employment. So if you've got a weak case, it may well be that you actually want to look at a fairly early settlement, and that early settlement might also be advantageous to the claimant who has no income. So they may be prepared to accept a smaller settlement, even though they know that if they waited till tribunal, they could end up with the maximum compensation. A longer wait for hearings is, I think, inevitable. Probably 12 to 18 months before you get into the substantive hearings. Now, some employers may say, well, we'd rather keep the cash in our pocket, because if the hearing isn't going to take place for another 12 to 18 months, we'd really just wait and see. We actually might wait to see if that claimant gets another job. So we're not going to part with our cash now. We will just wait for that, wait for the judicial decision in over a year's time. So there's going to be a gamble on when you settle. And I think, there's going to be quite a lot of head scratching on when you put in those offers of settlements. One consideration that I think you need to look at in respect of claims is, are your witnesses still going to be there in 12 to 18 months? So with, with a lot of redundancies taking place and expected in the next 6 months or so, you may find that you have an employment tribunal claim, but your witnesses have disappeared because perhaps they've been made redundant. So consider, when you are making redundancies, is that individual somebody that is going to be, pivotal to the defence of the case in 12 to 18 months' time? And if they are, make sure you take some statements and get some cooperation from that individual now, so that you're not finding yourself without the necessary evidence to defend a case in 12 to 18 months' time. A turn to alternative forms of dispute resolution. Well, the employment tribunals, still have judicial mediation as an option. But again, I expect that will be, delayed in terms of the periods of time that the employment judges are able to devote to judicial mediation. So we might see more workplace mediation cropping up. We might see more, particularly on senior employment tribunal cases, on senior employee cases. We may see more arbitration perhaps being put into place. And of course, you still have the options of settlement agreements. There is one issue that seems to be sort of doing the rounds at the moment, with employers perhaps thinking employers are going to be more tolerant with employer decisions that have had to be made quickly with COVID-19 pressures. And I think it's quite interesting that, employers have got a hope that there's going to be a greater tolerance by employment judges. I think that hope is a little bit misplaced. I think that, employment judges will simply say, if a claim fits within a legal framework, then it is what it is. Without looking at the pressures of COVID-19, the employer was still expected to get things right, and particularly where that employer, has sufficient resources at its disposal. So, at the moment, the reasonableness perhaps of process will be looked at by employment judges on the basis of, size and administrative resources of an employer. So, smaller companies might have a little bit more wriggle room with this. But don't expect that COVID-19 is going to be your sort of get out of jail card in terms of going to a tribunal in 12 months' time and saying, actually, we didn't have time to carry out a fair redundancy process, or we didn't have time to wait for people to respond to our letters about pay cuts. If the claim is fitting within that legal framework and the claimant, has a good case, then they will inevitably be successful, regardless of, all of the pressures you might add at the current time. So again, passing back to Rustam, I think, Gary's view on employment judge tolerance of COVID-19 pressures would be really useful to hear. But Rustam, back to you.
Yeah, thanks very much, Rebecca. That's great. Yeah. So, Gary, and of course, don't want to embarrass you in any way. Two questions for you, really. Do you have a view on that point? And it's interesting because a couple of the questions that I know you've answered, Gary, this morning have been, in fact, the other way round, and saying, will employees be given greater latitude in the context, perhaps, of bringing a claim out of time because of the pandemic? And of course, in a sense, what Rebecca's been talking about is almost the other side of that coin. To what extent might employers be given a slightly easier ride in the context of difficult circumstances, etc.? So that was one question. And then the second was just your view as to the likelihood of the reintroduction of tribunal fees.
Okay. So far as the first point is concerned, and again, we're looking at unfair dismissals, really. Under Section 98(4) of the Employment Rights Act, you determine whether something is fair, unfair, reasonable or unreasonable, depending upon the circumstances of the case. And so therefore, Rebecca's quite right, or it is quite right to say that the background to any process is going to be relevant. But I think it is, I can't see that it's, so answer is yes, that sort of thing will have an influence, but it can't be said whether it's going to be either one way or the other, because it's going to depend upon the circumstance. So it's just going to be another factor to take into account with all the rest of the factors. You asked for two things. Can I just insert one thing about which Rebecca suggested in respect of judicial mediations and the fact that you may have to wait for them? My experience, both in the region that I sit in, which is in the Midlands, and also from discussing matters with the regional judge down in the West Country, and I know it's the same in London as well, is that a lot of the work that full-time employment judges do are long multi-day cases, and that takes up a lot of their daytime. Those are not happening at the present time. They still have a lot to do, but I've been told, certainly in my region, that if a party wishes to have judicial mediation, that can normally be facilitated in very short order, because there is scope, there are judges available for it, there are rooms available for it, and also, of course, it is a way to cut down on the huge waiting list that is going to be critical in months to come. So therefore, if you are minded for judicial mediation and you want to see an end to a matter, the view that I take is, if you make an application, if you made an application today, I would think that you would certainly get a judicial mediation date in August at the latest, maybe September, but it will depend from region to region. But you clearly have to do that. The last point is in respect of employment tribunal fees. It's no surprise that they will be making, or they suggest they'll be making a reintroduction. The scheme itself will obviously depend. I mean, the reality was, on the last occasion, it was a prohibition to justice. The suggestion was that the long claims and the ludicrous claims wouldn't happen because of fees. Certainly my experience was that those were exactly the case that still stayed in, because the passion was still there for those cases. What was lost was the unlawful deduction of wages claims and the straightforward breach of contract claims for relatively small amounts of money, but important amounts of money for the employees who are dealing with it. So I'm not surprised that there will be fees are on the agenda, but obviously it's going to have to be a far more balanced fee structure than on the last occasion. Of course, again, and I expressed earlier that I'm not cynical in any way, shape or form, but of course, on the basis that there is an enormous backlog of cases, one could be forgiven for thinking that part of the rationale behind it may well be that fees would be a way to reduce the flow of future cases in order to get matters back to a certain level. I couldn't possibly say, of course.
Couldn't possibly comment. Thank you, Gary. And then just sort of one last question for you, if that's okay, on this section. As you sit as a part-time employment judge, have you seen any particular changes in the shape of new claims that are starting to come in?
I think the problem for that is that as a fee-paid judge, I mean, I've sat regularly, but I've sat in exactly where I am now, remotely doing effectively telephone hearings. I haven't judged a remote hearing yet. I've appeared as a barrister for many, but I haven't dealt with the judging there. So I'm afraid I can't really give any clear indication in respect of that. And also, of course, as Rebecca rightly said, the staff are stretched. The staff were cut enormously in the first place after the fees. It's never got back to the normal level despite this case level going up there. So the staff are stretched at the best of times. At the moment, there was only running on about half staff. And so therefore the gaps between the claims being processed, there's still quite a long lead time. So therefore it's too early to say.
Sorry, Gary, I've got to get one more question in because we've got you. So just in the context of the, maybe not the sorts of claims, but just maybe the numbers of claims, do you have any feel for that either in your own region? I know we were chatting previously, or sort of what's happening kind of around the country.
My understanding is that the claims that are coming in are increasing on the base in line with the fact that there are the unemployment rate has gone up largely in the last couple of months. So those cases are still starting to filter through, of course, because they have to enter early conciliation. So even if somebody was furloughed in March and that claim may not be making its way through as yet. But I mean, certainly the system is bracing itself for a substantial number of claims. And as an example, I know at the present time there is a there is an advert that is now closed, but there are going to be another 25 full-time employment judges to be appointed across the country, with an emphasis in London. That's what this advert suggests. And also, I know that again, this may be of interest to people who are out there. I know that they are looking to recruit more fee-pay part-time employment judges, such as I am at the present time, and also looking for a further recruitment in due course for lay members.
Gary, that's incredibly helpful. Thank you very much. Just looking at time, so we'll just move on to the last section, which we'll try and deal with relatively briefly. So the Law Commission, just as they've been asked now by the government to look at the possible reintroduction of fees, the Law Commission were previously asked to look at the operation of employment tribunals. They've made some recommendations. It's important to note that they are only recommendations, and also that the Law Commission wasn't asked to carry out a full-blown review. In other words, to rebuild the tribunal system from ground up. It was a question of focusing on perhaps some anomalies, looking at where efficiencies could be achieved, and also considering the question of whether there is an over-separation between the employment tribunal system and the mainstream civil courts. So if we move on then and we look at some of those recommendations, well, probably one of the most important amongst them, and it touches again on some of the questions that people have been asking this morning. The recommendation is that the limitation period for statutory employment claims should be raised to 6 months across all jurisdictions. I'm sure most of you are aware that in most cases, the current limitation period is 3 months less a day. The only main exception to that relates to claims for a statutory redundancy payment. So the recommendation, though, is if you like to level up, or if you're a respondent, perhaps level down to 6 months for all jurisdictions. And then the allied point to that is that where a claim's brought out of time, the tribunal has a discretion as to whether or not to extend time and allow a claim in late. And at the moment, we have two different forms of discretion, one that's often referred to as something that's not reasonably practicable, and another which is just and equitable. And I think it's very widely recognised that just and equitable as a formulation is much more claimant friendly, much more permissive than the not reasonably practicable. And the recommendation is that as well as increasing the time limit to 6 months, that also that there should be a uniform approach in terms of claims that are otherwise out of time, possibly allowing those claims to be brought where the employment judge considers it just and equitable to do so. So just as possibly Gary's right that reintroducing fees might dampen down some demand, as it were, it's of course right equally to recognise that there are a number of claims that might now go ahead and continue because they'd still be in time. And maybe politically that's how it will all be sold in due course, that it's giving with one hand and, as it were, taking with the other. Another recommendation is that employment tribunals should have the power to make declarations in relation to certain working time claims. At the moment, we have a situation whereby certain working time rights can be exercised and enforced through the employment tribunal, but the employment tribunal can't make a declaration. For instance, has someone exceeded a particular number of working hours? That technically is a declaration which would have to go into the civil courts, but then the civil courts don't have the power to enforce rights or to provide compensation for breach. So it's trying to bring it all under one roof and bring it under the employment tribunal route. Similarly, equal pay claims, at the moment it's possible for claims to be brought in the employment tribunal as well as in the mainstream civil courts, and there are various tactical reasons as to where they might be brought. Now, what is being recommended is that generally there'll be a presumption that claims should be brought in the employment tribunal, but, and it's an important but, that isn't going to apply, or its recommendation is that shouldn't apply to pension claims, where it's a matter of very often very technical calculations in terms of the value of the loss that's potentially been suffered. they would stay still in the civil courts. I think some other recommendations which are probably quite important for employers to be aware of is that the claims for breach of contract, which at the moment can be brought in the Employment Tribunal, but there is a limit of £25,000, that limit would be increased to £100,000. And also quite important, I think, that the breach of contract claims could be brought while someone's still employed. At the moment, in order to bring it in the Employment Tribunal, the employment must have come to an end. Again, it's important, as I say, to recognise that this is where there is a dual jurisdiction. So the civil court claim can be brought currently, whether the employment has ended or whether it's continuing. But another extension is the suggestion that breach of contract claims which relate not just to employees, but also to workers could be brought within the Employment Tribunal. And then a couple of others recommendations. One is about unlawful deduction claims. We have the situation at the moment where the employee might bring a claim that perhaps they haven't been paid correctly, and that therefore they've got an unlawful deduction claim. But the employer might say, yes, but you owe me some money. Well, at the moment, the employer can't essentially set their claim can't set off their claim against the employee's claim. So the recommendation is that that should be tidied up. And then finally, in terms of recommendations, there's also the recommendation that employment tribunals should actually be able to not just not just determine what a Section 1 statement term should be. So, for instance, somebody gets their Section 1 statement of terms, but it's silent on a particular point which should be dealt with under Section 1. And so at the moment, the Employment Tribunal can make effectively a declaration and say, that's what we think the term is. But what they can't then do is go on and say, and now applying that to this particular case, this is what we think it should be, and this is what we think the employee should receive. Effectively, the employee has to go off and lodge another claim all over again. So the suggestion is that effectively, as well as determining what the term is, that the Employment Tribunal should then be able to go on and apply it. So just in terms of mopping it up, there's also some suggestion that there should be some greater power for tribunals to be specific as to the contribution between respondents in discrimination claims. So classically, where perhaps the claim is a claim, for instance, of sex or race discrimination against the employer, but also there is what we call a named respondent. So perhaps there's the manager or maybe another employee that's perhaps particularly responsible for the actions complained of. So that would mean that the tribunal could say, well, we award effectively, in broad terms, £10,000 against the employer, but we're also going to award and say that £5,000 has to be met by the employee. So in other words, separating it out and being quite specific. And then finally, recommendation from the Law Commission is that there should be a more effective enforcement mechanism in relation to tribunal awards. And Gary, Rebecca and I will all know that as long as we've been practicing, this has been an issue in that some employers do play by the rules, and when they are found liable, they do pay. Other employers seek to avoid it. I wouldn't say it's easy to avoid, as it were, but employers do seek to avoid it. And this has been an issue because the Employment Tribunal does not have its own enforcement mechanism. Essentially, an employee has to go to the civil courts or sometimes to the sheriff in the High Court and seek to enforce a money debt, just as you might enforce an ordinary debt. And so it's felt that this means that sometimes the remedy is not fully effective, and so the Law Commission's recognised that. Unfortunately, though, I have to say I think they've ducked it because they've said, yes, there should be a more effective enforcement mechanism, but we don't think the Employment Tribunals should be given it. So I think it sort of passes the, as I said, ducks it, passes the hot potato back. So what's going to happen next? Well, we ought to see a ministerial response in this autumn, and then if legislation is to be introduced in ordinary course, that should come out in sort of spring of next year. As I say, it might be that that then ties in neatly or nicely, depending on your point of view, with the reintroduction of employment tribunal fees. So that's all that we were going to talk about this morning. I'm mindful of time, so hopefully Gary and Rebecca will forgive me if I don't ask them for their further comments on those. Just to confirm, as I say, on the questions, we will pick those points up and we will put together a sort of a question and answer sheet and circulate that. I hope you found this morning useful. I also very much hope that you'll join us for our next webinar, which will be a fortnight today, which I think will therefore be on the 9th of June. It'll be the same time. And the topic there will be flexibility. Now, we know, of course, that from the 1st of July, the furlough scheme is going to become much more flexible. But there's also, I think, the ongoing issue of flexibility, as it were, in the contract of employment generally. And certainly we're seeing a number of employers asking us to look again at contracts in the context of how to improve and increase the level of flexibility that employers have. So we'll be looking at the issue of flexibility. I suppose flexibility, furlough and beyond will be our topic in a fortnight's time. So it just remains for me to thank Gary Self very much for joining us this morning. Thank you, Gary. And also to thank Rebecca from DMH Stallard also. So I hope you've all enjoyed it, and I wish you all a very good day. Thank you.